notice under 148A within bracket small b will have to be issued. Then a hearing would take place. Then, my lords, the assessing officer will have to pass an order calling it as a fit case for the purpose of issue of notice, which order will have to be passed with the prior approval. And, my lords, as soon as the said order is passed, which is an order under 148A within bracket small d, my lords, a notice under 148 would then be issued. My lords, what happened was, my lords, after 1/4/2021,
The new regime,
the new regime,
the faceless regime.
faceless, I'll come to, my lords.
Yes.
Faceless is one aspect. This is the normal aspect of how a reassessment should be made. So department did error in as much as it did not follow the new regime. It went ahead and issued notices under the old regime, which, my lords, most of the honorable high courts, including this honorable high courts, quashed this on the premise that you have not followed the new regime. Then, my lords, the matter reached the honorable Supreme Court. Honorable Supreme Court, in respect of those matters then existing, lords, which came before the Supreme Court, stated that new regime has to be meticulously followed. And the Honorable Supreme Court concurred with the decisions of all the high courts to state that if the old regime is followed, it is bad. And therefore, my lords, what the Honorable Supreme Court did is to deem the wrongly issued notice under 148A within brackets B and asked the department to proceed. Thereafter, my lords, the fairless regime started. The department in those cases also continued the error of proceeding manually on it. That apart, this batch before, my lords, would also consist of those cases which were initiated on the new regime only, but not through the fairless regime. Therefore, my lords, these petitions are before, my lords. Now, my lords, the provisions in the Income Tax Act, my lords, in respect of various proceedings were intended to be done in a fairless manner with three avowed purposes in mind. That's one is to remove the interaction between the assessee and the department. This would enhance the transparency. Two, my lords, dynamic jurisdiction. My lords, they wanted to get rid of the conventional method of the jurisdictional assessing officer, which would then mean, my lords, there wouldn't be proper optimal utilization of resources within the department. So dynamic jurisdiction where, my lords, I could be assessed by somebody in Tripura. So this was what this was brought in. Then at the same time, they also introduced the fairless assessment schemes and the procedures. What they did in this regard, my lords, most importantly, three important provisions will have to be taken note of, my lords. One is section 130 of the Income Tax Act. Through 130 of the Income Tax Act, my lords, they have brought in they have enabled the central government to issue a scheme for fairless conferment of jurisdiction. Otherwise, my lords, the jurisdiction would be conferred by the order of the Central Board of Direct Taxes, delegating its lower authorities to in turn delegate, my lords, the powers of the assessment. All these orders are essentially passed under section 120, read with section 124 of the Income Tax Act. And, my lords, section 130 was enacted to enable the board to bring out a scheme to seamlessly confer the jurisdiction. I'll explain why this is done, my lords. And accordingly, a scheme has been brought in to confer fairless jurisdiction. Along with that, my lords, they have brought in 144B with effect from 1st of April of 2021, where they have codified the whole scheme of fairless assessment, not as scheme, but as part of the statute. Unlike in 130, my lords, where a scheme has to be brought out by the Central Board of Direct Taxes, under 144B, they have enacted the fairless procedure itself. Thereafter, my lords, they also brought in 151 capital A, which provision, like 130, enabled the Central Board of Direct Taxes to issue a fairless scheme for the purpose of, my lords, carrying out the exercise of issue of notice under 148. So I may clarify one thing, my lords, here, that 151A scheme provided for stage up to the issue of notice under 148. And thereafter, the assessment in a fairless manner will have to be done under 144B. The whole, if, my lords, were to look at all this in an integrated manner, how it works, my lords, is the cases for reassessment would be picked largely on the basis of risk management strategy, which, my lords, is a strategy adopted by the Income Tax Department applying artificial intelligence and the machine learning, where, my lords, they will have the set risk parameters. On the basis of those set risk parameters, the cases will get flagged. And as they are flagged, my lords, they are to be picked for the purpose of reassessment.
Reassessment.
And as soon as the cases get flagged in the RMS, which is without the human intervention, then, my lords, the system is so integrated, so much so that the jurisdiction under 130, my lords, would get conferred to by way of an automated allocation algorithm
To
somebody. Somebody
Yes.
who assessee wouldn't even have a chance to know. So it will get allotted to somebody. As soon as that gets allotted, my lords, section 151A will kick in for him to initiate
Proceedings.
the proceedings as to whether it's a fit case for issue of notice and
Reassessment.
reassessment. And once, my lords, so-called officer passes an order stating that it's a fit case for issue of notice under 148 and hence issues a notice under 148, my lords. Likewise, the section 130 would work in a manner where it will then go to a phaseless officer for the purpose of assessment under 144B. So this is how, my lords, it's all integrated. This being the case, my lords, and this being mandatory, the question before, my lords, is department right in not following this faithless system? So with this brief
Now,
background,
one clarification,
My lord.
as I heard on the last occasion.
my lords,
Now, despite all this being in place, the notices are manually issued,
Exactly.
proceedings are manually taken, and orders are passed.
exactly.
That is in violation of
Mandatory,
mandate which Supreme Court says you have to follow.
exactly.
Yes.
Now, my lords, with this background, I would take, my lords, to section 151A.
Yes.
And before that, my lords, 130, maybe just kindly seen, my lords, that would make it complete. These three sections are very critical.
Page?
My lords, may kindly take
I'm
section
holding
130.
I'm holding writ petition 17352.
My lords, may kindly take the Income Tax Act.
Ah. One fifty,
This section, my lords,
one
at page 1.924,
1.924. Yes, sir.
my lords will find section 130 on the left-hand side,
Yes, I am there.
faithless jurisdiction of income tax authority.
Yes.
Now, my lords, this would provide for, without bothering my lords reading this, it will provide for bringing out a scheme to confer faithless jurisdiction. A scheme also has been brought in place, my lords, which at this point in time may not be really relevant. Now, my lords, may kindly go to 144B of the Income Tax Act,
144B.
capital B, my lords.
Yes.
My lords will find in page 1.1004 on the left-hand side.
1.1004.
Yes, my lords, on the left-hand side.
Yes. 144B.
144 capital B.
Yes, I am there.
Now, my lords, on the left-hand side,
Yes.
faithless assessment,
Ah,
notwithstanding anything to the contrary contained in any other provision of this act, the assessment, my lords, may also kindly notice reassessment.
ah.
My lords have found that?
1 minute, 1 minute.
I'm sorry, my lords. Or my lords referring to 2025 Act,
120, yes, yes.
1.1004.
25, yes. 140 faceless assessment.
Yes, my lords, 144B, subsection 1.
Yes,
What my lords are reading is effective 1/4/1922.
yes.
Notwithstanding anything to the contrary contained in any other provision of this act, the assessment, my lords are there,
Yeah, I'm there. Yes.
reassessment, recomputation, my lords may kindly see reassessment as well, recomputation under 143(3), 144 and 147, which is reassessment section.
Yes.
As the case may be, with respect to cases referred to in subsection 2, shall be made in a phaseless manner as per the following procedure. Then, my lords, the whole lot of procedure will continue from page 1.1012 onwards. So, my lords, at this point in time, it may not be necessary, my lords, to take, except noting that, my lords, that the scheme is itself codified as in the form of section. Now, my lords, may most kindly go to the important section here, 151 capital A.
151A.
Capital A, my lords, which my lords will find in page 1.1040.
1040.
Yes, my lords.
Yes, I'm there.
Lords, on the left-hand side, faithless assessment of income escaping assessment.
Yes.
Subsection 1.
Ah.
The central government may make a scheme by notification in the official gazette for the purposes of assessment, reassessment, or recomputation under section 147 or issuance of notice under section 148 or conducting of enquiries or issuance of show cause notice or passing of order under section 148A or sanction for issue of notice under section 151 so as to impart a greater efficiency, transparency and accountability by A, eliminating the interface between the income tax authority and the assessor or any other person to the extent technologically feasible. B, optimizing utilization of the resources through economies of scale and functional specialization. C, introducing a team-based assessment, reassessment, or recomputation or issuance or sanction of notice with dynamic jurisdiction. Then, my lord, subsection 2 is also equally important. The central government may, for the purposes of giving effect to the scheme made under subsection 1, by notification in the official gazette, direct that any of the provisions of this act shall not apply or shall apply with such exceptions, modifications and adaptations as may be specified in the notification. That is a cut-off date for issue of that. Now, my lords, subsection 3 is equally important. Every notification issued under subsection 1 and subsection 2 shall, as soon as may be, after the notification issued, be laid before each house of the parliament. Lord, this section empowers the Central Board of Direct Taxes not only to issue a scheme, but also, my lords, specify that other provisions of the act should not apply if the scheme were to come in. Obviously, to the extent of incompatibility and inconsistency.
That's not the
And also, the notification so issued by the Central Board of Direct Taxes will have to be placed before both the houses of the parliament. Now, my lords, in exercise of powers under this particular section, notification has been issued, my lords. I may share this convenience compilation, my lords.
It's already there in the paper book. It's already in the paper book given by
Shankar sir.
at page.
It is here.
The scheme is at page 112, 212.
Let Chaitanya sir finish.
My lords.
Yes, sir.
My lords, this scheme is notified on 29/3 of 2022, my lords.
Where do I get
Do I
that?
share this, my lords? My lords,
Yes, give it.
Yes, yes. Lords, at page 1. May I read this, my lords?
Yes.
In exercise of powers conferred by subsections 1 and 2 of 151 capital A. My lords, may kindly take a pause here.
Yes.
This is issued not only in exercise of powers under subsection 1, it's also issued in exercise of powers under subsection 2, which enable the board to notify those sections which should not apply or should apply with such exceptions, modifications and adaptations. Therefore, my lord, this would to that extent override those repugnant provisions of the Income Tax Act. Then, my lords, the central government hereby makes the following scheme, namely, this scheme may be called as e-assessment of income escaping assessment scheme 2022. It shall come into force with effect from the date of its publication in the official gazette. Then, my lords, definitions. Clause B may kindly be seen, my lords. Section 2(1)B, automated allocation, means an algorithm for randomized allocation of cases by using suitable technological tools, including artificial intelligence and machine learning, with a view to optimize the use of resources. That is how, my lords, the cases will get allocated. Then, my lords, the words and expressions used herein but not defined, but defined in the Act shall have the meaning respectively assigned to them in the Income Tax Act. Scope of the scheme, this is important, my lords. For the purposes of this scheme, there are two limbs there. A, assessment, reassessment, or recomputation under section 147 of the Act. B, issuance of notice under section 148 of the Act. Shall be through automated allocation in accordance with the RMS formulated by the board as referred to in section 148 of the Act for issuance of notice, comma, and in a phaseless manner to the extent provided in section 144B of the Act with reference to making assessment or reassessment of total income or loss of the assessee. Well, lords, there are two limbs, as my lords have seen in this notification. One, my lords, is assessment, reassessment, recomputation under section 147. Two, my lords, issuance of notice under section 148 of the Act. My lords, my first humble submission is, this notification is dated 29th of March of 2022. Whereas from 1st of April of 2022, the assessment, reassessment and recomputation under section 147 has to be made under 144 capital B, which will start with a notwithstanding clause, non-obstante clause. Therefore, my lords, the scope of this notification may kindly be confined only to the second limb of it, that is issuance of
The notice under section 148 of the Act.
Yes, my lords.
Yes.
My lords, section 147, which gives, my lords, room for doing reassessment, is subject to provisions of 148 to 152, which will inter alia include 151A as well, 148 as well. Therefore, my lords, the whole of reassessment as is coming in section 147 is subject to those sections as is stated in section 147.
Inclusive of 151A.
Up to, which includes inter alia 151 capital A. Now, 151 capital A, my lords have found that the board is enabled to bring a scheme. The board has brought a scheme. The board has brought a scheme whereby, my lords, it says issuance of notice under section 148 shall be through automated allocation in accordance with RMS formulated by the board as referred to in section 148 for the issuance of notice, comma, and in a phaseless manner. Therefore, my lords, it has to be necessarily by way of automated allocation, and it has to be necessarily by way of phaseless manner. My lords, the parliament has used the word shall, the board has used the word shall here, my lords, which essentially indicates that there is no choice left to the revenue.
Mandatory.
It's mandatory, my lords. The Honorable Constitution Bench in Anjum Kasawala, my lords, in 252 ITR 1 has held that shall necessarily indicates the mandatory nature of it. Therefore, our first humble submission, my lords, is when the procedure is laid down none other than by the board which is at the helm of the affairs, it